I want to take some make doctors labels. Did I tell you about my plane trip back from China? So we got on the plane, and we're all sitting there, and there's like this group of at least 30 Chinese men that are crowded around these 5 seats where these guys are playing, I think, craps or something like that. And they're all, they get to gamble, they're on the plane, they can't be arrested for gambling. The flight attendants literally like beat backs. There's this big blob of just like older Chinese. It's pretty great. So, they're being super loud.
Good afternoon, ladies and gentlemen. Speakers Committee, Special Committee on Litigation Reform is about to convene. We are expected to conduct ourselves with the courtesy and decorum expected of us as representatives. Mr. Secretary, please call the roll.
Chairman Lant.
Here.
Vice Chairman White. Present. Representative Minton.
Here.
Corlew.
Here.
Cornejo. DeGroat.
Here.
Albrecht.
Here.
Carr. Hill. McGough.
Here.
Phillips.
Here.
Rader.
Here.
Roberts.
Here.
Quorum being present, Special Committee on Litigation Reform will now go into executive session. Mr. Secretary, you will please call the roll. Okay.
I can go and do
All right, I now move that Senate Substitute Number 2, Senate Committee Substitute, Senate Bill 43 be voted to pass. Any discussion? Representative Midland.
Thank you, Mr. Chair. I have an amendment. It ends in .10H, and I move for adoption. .10. Yeah, that's the one. That's Stephen. May I proceed?
Yes, go ahead and proceed.
Okay, thank you. This amendment deals with the managerial portion of the whistleblower part of the bill. It basically creates a new definition for the exceptions under the whistleblower. It removes the existing language that during the hearing we knew there was some issues with. This was the part of the bill that the sponsor as to Medicaid fraud and the fact that under the existing language, even if a whistleblower were blowing the whistle to save taxpayer dollars, that the whistleblower would not have any protections. And the language, which is right there, that would be the new language for who is protected. It's just more specific.
Is there any discussion? Not appearing. All those in favor of adopting House Committee Amendment 1 signify by saying aye.
Aye.
All those opposed say no.
No.
The noes have it. You favor to adopt the amendment. Any discussion?
Thank you, Mr. Chair. I have an amendment ending in .04H, and I move for its adoption.
Any discussion?
I may briefly speak on the amendment. Thank you. Pretty much what this does is, there's a lot of talk about individual liability and responsibility. This brings us in line with the federal standards, allowing an employee, such as a manager or their agent, to be held responsible for their actions. All this does is keep the statute how it was, where it includes employees, and for the body will support it.
Additional discussion? Representative Albrecht?
The amendment offered by Representative Roberts, I think, is a good one, and I want to speak to some people that might have concerns with this, because I understand folks are partially motivated in this by trying to get these employment cases into federal court. But by adopting the federal standard, which we're purporting to do here today, our state courts will be adopting the case law and standards that have been previously in place. So essentially, it's not going to do anything except hold the individual bad actor accountable. Ability to do that through our state laws. It's not as though we're trying to attack motivating factor or, contributing factor. This is about what each and every one of us, I believe, thinks is important, and that's personal responsibility. When you have someone that does something bad, we expect that person. And in fact, I believe that businesses would probably like this as well, because the individual bad actor will share in some of this lawsuit. There's probably fewer people in the room that are as upset in an egregious employment discrimination case than the employer who finds out about the bad actions of their employee by getting served with a summons to come to court. And that happens. The upper level management may not be made aware of a bad problem or a bad situation, and they become made aware of it by getting a letter from a lawyer. That employer is probably going to be just as upset with that bad actor. And that bad actor, the message we're sending by passing this without individual liability is that the person who commits that horrific thing, who says those awful words to another person who's just showing up to get a paycheck to pay for their kids, to feed their families, to put their kids through college, that individual who says those awful things, who does those awful things, needs to be held accountable. We have the opportunity to do that here today by amending this bill and including that in. And it doesn't change anything about the standard of proof. It still creates a more stable environment for businesses to conduct their business in the future and do what they need to do with their employees. I encourage the committee to support this amendment because it does what we need it to do, and that's hold the bad actor accountable.
Additional discussion? Representative Hill?
To inquire of Representative Albrecht.
Go ahead.
Thanks. So can someone still be sued? Say the discrimination suit is settled and or whatever, it's done. Can someone still be sued individually for the actions they did to offend that other person?
It would depend on what they did. If they put their hands on them,
Yeah.
yes. So if it's a case where the employer and the employee are being sued in Missouri for sexual harassment, and there was an element of a physical touching, like an assault.
Well, we have the criminal law has sexual harassment without.
They have harassment and stalking. That's not the same as sexual harassment.
There's an exclusive remedy clause here.
So, but my question is, to Representative Albrecht, is can somebody be sued individually after the fact if the bad actor is carved out of statute under discrimination?
The way the bill is currently drafted, I don't think so. Unless you have a case where somebody was physically assaulted, and then you basically you just got a simple assault case, which is a civil act, which can be a civil action. But if your damages aren't high, in other words, if the person wasn't injured or anything, it's going to be difficult to, because then you're looking at somebody who there was a woman in the workplace who was sexually assaulted, but the sexual assault was something that obviously somebody should get fired for and isn't like acceptable behavior, but it's only like a groping kind of thing where they weren't injured badly or any of that stuff. Then now, in order to prove up that assault case, to make it worthwhile for her to go to court, she's going to have to go seek counseling and incur actual damages in order to make it enticing to get an attorney interested in that lawsuit. Because otherwise, she's just like, this guy touched me. Okay, we'll put it in front of a jury, and the jury's going to say, what's that worth? And she's going to have to testify to what her damages are in order to support that claim. If she doesn't have a record of damages, then, and also to Representative Mitten's point that this abrogates the civil liability for the individual bad actor after the fact, in terms of me being able to sue somebody for, you know, an assault that occurs. But I do think that it raises real questions if that assault occurs at the workplace. Is this truly the exclusive remedy? Because that exclusivity in the remedy clause actually might abrogate your ability to move forward against the individual bad actor.
Okay, so what's occurring now, though? Is it true that that trial attorneys are using the bad actor to seek a higher judgment against the employer? Are they trying to turn them as, you know, as excellent witnesses against the corporation? I mean, is that where all this comes from? This removing individual liability?
No, everything that I've heard, and I don't know the whole answer to that, to be honest with you. Everything that I'm hearing is that this is an attempt to get it moved into federal courts.
Does it occurs? Do you think?
Do I think that there are trial lawyers who have used the current standard?
Yeah.
Yes, I do.
Yeah. So we're here. We're not here for.
No, this is absolutely. We've had this. So you and I personally had this discussion where maybe in order to create a more friendly, I guess, business climate, which is fine if that's going to be the public policy, if that's going to be the priority of the body. I personally disagree with it, but I understand it. And I do think that some change might be appropriate in order to raise the standard. I don't know that we need to raise it this high. I think the difference between, and I have an amendment that I'm going to offer in a bit that addresses this, because by using the language we're using, we're actually rolling back to pre-1991 standards rather than what Congress did in 1991 when they amended Title VII. So that now, currently under the law, the jury instructions I brought last week are informative. The jury instructions actually say a motivating factor, but the language we use in the statute is similar to the age discrimination cases that were being brought in 1991.
Yeah. All right. Thanks. Thank you, Mr. Chair.
Additional discussion? Representative White.
Comment, Mr. Speaker.
Go ahead, sir.
Well, a lot of emails and things on this bill over the weekend, but I have a lot of face-to-face interaction with my constituents. And with the exception of one, this was the issue they brought up. Why would the state not want to, in an employment discrimination case, the person that is doing discrimination, why are we not going to hold them liable? Why are they not going to be able to be a party to an employment discrimination case when that is exactly what it is? And, you know, my constituents aren't all attorneys. These are everyday people that don't, you know, they have the same amount of law knowledge I did before I went to become a lawyer. Answer. We can be looking at venue, which is one of the things I've heard. If you want to either look at federal court, look at staying out of, you know, our judicial hellhole places, that sort of thing. But the logic of why we are not going to go after the individual that is actually with or without the company's knowledge. And I mean, this is a question of fact that the juries decide. You know, did the company know this was going on? Did they have all the right things in place? They had the 800 hotline numbers, they had everything, and somehow this was circumvented. We had a testimony from a trial attorney here that, you know, once in a while the company gets off and the guy doesn't, or the gal. In that case, I think he said guy, but the individual doesn't. I cannot give my constituents a good answer, a fair answer. I can tell them, well, maybe we're looking at venue. They don't understand venue, but is venue a fair answer? And I don't think that it is, in a sense of fairness, which is what our law desires to do, justice and fairness, that we should relieve an individual in this case, because this is in the employment setting. This is, you know, to have to go after infliction of emotional distress, to do an assault. This is a whole nother separate case, a whole nother cost, a whole nother time of going through doing your witnessing, your testifying, that can be very stressful. And in response to Representative Hill's comment, I mean, if you've got a bad actor who's done this and he's not named, there's nothing that says that travel attorney is going to try to turn him and say, oh no, this was the culture and it's not my fault. I mean, I think it's just as likely you're going to have an individual to try to protect himself from any potential futures going after the company too. If they're going to flip like that, I think they're going to flip whether they're named or not. I think that the amendment is fair. I mean, I totally support this bill. I'm even okay with the determinative factor, which really, when you read it, is a determinative factor, which is to me a 51% test, 50 plus 1 test to me. I'm okay with that part. We need to do that. And I think a lot of our members on the other side of the aisle agree that it's swung way too far, but some amendments I'm going to be offering and other provisions other than this standard that make it so that I can, in its current form, support the bill. And this, to me, I have not heard. I talked to several of our business entities. They told me nothing. I could tell my constituents why we wouldn't vote for this amendment. Thank you, Mr. Speaker. Or, sorry, Mr. Chairman.
Representative Roberts.
Thank you, Mr. Chair. This bill affects the constituents of every person in this room, and I would like a roll call vote.
Have your roll call. Representative Minton.
I just want to quickly respond to some of the comments. As to representative from the Hill District, the problem is that with all due respect to my colleague, these claims all arise out of the same actions. And I don't think that, given that there's this exclusive remedy clause at the bottom of page 12 of the bill, I don't think that you get to file a separate assault charge against the manager that actually did the wrongdoing. I don't think that that's possible. I think that your only claim, because this bill specifically excludes that person, that your only claim can be against the employer. And I just want to sort of touch base on that. Now, reasonable people can obviously disagree, but I think that at a minimum, the first claim brought, if this were to become law, that aspect of it is absolutely going to be litigated. Thanks.
Any other discussion? Representative Corley.
Discussion.
Go ahead, sir.
Thank you, Mr. Chair. I think we need to consider what the purpose of the MHRA was at its beginning, and that is to provide remedies for unlawful discriminatory practices in the employment setting and in the housing setting. As pertains to this amendment, we're talking about the employment settings. There's been a lot of discussion today as far as who is the bad actor and holding the bad actor accountable. For purposes of the MHRA in the employment setting, the bad actor is the employer. The employer is not getting off the hook under this bill. It provides for remedies and lawsuits and damages against the employer. I think we're trying to stretch the MHRA to be something that it's not. It's meant to apply in the employment setting. It's not meant to apply for all the other bad things that happen in our society. There are other remedies for that. But as it pertains to the employment setting, the bad actor is the employer. That person is not being let off the hook under this provision. Also, take a look at where we are in terms of what this legislation is supposed to provide. It's supposed to bring balance to our court system. Right now, we're one of only a handful, I think 2 states that use a contributing factor stance. So we're an outlier. This bill in no way takes us to an outlier in the other direction. In fact, more than 70% of states do not provide an individual liability provision. So it's not the case that every state is providing these same provisions. In federal law, and it's in more than 70% of the states, you have similar standards as to what we're implementing here to balance our court system, to make this an environment where our businesses can do the business that they need to do here and still provide meaningful protections for discriminatory practices. This amendment would not change that and would move us again into another outlier, just in another direction. And so I'd encourage the committee to vote down this amendment. The bill in its form is a good bill, provides for good protection of discriminatory practices in the housing and the employment setting. A number of these things are, and keep in mind too, the remedy, the intent is to provide compensation for those who are injured. This bill provides that. This wasn't meant to be just a punitive type of against individuals. This is meant to hold the bad actor employers responsible and to give compensation. Some of these other areas are not only compensatory under this act, but also under workers' compensation and the other acts that are provided for. So I'd encourage the group or the committee to vote down this amendment.
Additional discussion, Representative Roberts?
Thank you, Mr. Chair. The purpose of this bill is to make discrimination just a cost of doing business. And if you can say it's not, but that's the effect it has. Thank you, Mr. Chair.
Additional discussion? Seeing none, roll call has been requested. Mr. Secretary, you will please call the roll.
Chairman Lant,
Aye.
Vice Chairman White.
Aye.
Representative Mitten.
Aye.
Representative Corlick.
No.
Cornejo.
No.
DeGrove.
No.
Albrecht.
Aye.
Carr.
No.
Hill.
Pass.
McGough.
No.
Phillips.
No.
Rader.
No.
Roberts.
Yes.
Hill.
No.
I changed my vote to no. By a vote of 4 ayes and 9 noes, the amendment has failed. Additional discussion?
Thank you, Mr. Chairman. Mr. Chairman, I have an amendment. Actually, I have two. The first one ends in .13H, and I move for its adoption.
Discussion?
If I may discuss why the purpose of the amendment in both the MRSA portion and the whistleblower portion pulls out the phrase that deals with the exclusivity of the chapter that this chapter, in addition to chapter 285 and 287, shall provide exclusive remedy for any and all claims for injury or damages arising out of the employment relationship. Got a bunch of emails out there pointing out this is not an area of law I practice in. One of the things this does block is section under 188. Looks like that. Which is how we protect our nurses and our physicians from being fired for not doing an abortion. There's different, and there's also then we get child labor statutes, which are in a different chapter also. This is a drafting issue, I think, on when you say exclusive remedy for any and all claims. We have lots of other things, child labor. This is very important to my conservative side that this is the law that keeps a nurse from being fired if she worked in a hospital that decides, or in a clinic that for some reason is going to be doing an abortion. And it's either you do the abortion or you get fired. It's something that was very strong to all of us. When this was passed, I was up here. I know at least we've modified it since I've been up here. It's too broad. I don't think there was a sufficient amount of research done. Little things like this that, it's in a non-employment area statute because of its topic. So this just pulls it out of both sections. It leaves child labor, it leaves the abortion issue, anything that we already currently have in law that our legislature's passed that relates to actions for resulting from employment, this allows to stay in. It isn't anything new, it's just saying what we've already got there is there, because otherwise if we do this, only these two chapters are what we get to do, and that takes out the abortion issue, child labor, and I'm sure there's more of them out there. Thank you, Mr. Chairman.
Additional discussion? Not appearing? Representative Hill? Or Representative Cornejo? Corley.
inquire, please, the amendment maker. You're under .138, right?
I am 138, yes.
Okay.
And it is in both sections, the whistleblower statute and the other section.
Okay, and as it pertains to page 12, what are you trying to do to that?
We are taking out subsection 2, basically, line 16 through 18. We're just taking them out. Because that's where it says the exclusive is just within this chapter, the other two. Basically makes 213, 285, and 287. If you're not in those chapters, any law we have out there that relates to employment relationship, damages arising out of is out. And that does include 188, which is the abortion provisions. I don't know the number off the top of my head of the child labor stuff we have. And I'm guessing there's probably more. I don't practice Missouri law, so I've had to rely on people pointing this out.
Okay, and is it your understanding that Missouri law can unintentionally repeal another statute like that?
Yeah, when we say notwithstanding, or when we say shall be the exclusive remedy, at the minimum, you create a conflict that the court will have to resolve.
Well,
And if you say these two chapters are the only remedy, and there's a third chapter out there, then the courts are going to have to say, well, do we mean this statute's here? Now this statute says these two are the only exclusive. You're going to get a court case on whether you're going to get the court making the decision on which one of these two statutes is going to really be, is it exclusive or not?
But isn't it a long-held statutory construction that the repeal of statutes by implication is not favored by the courts, and the presumption is always against the intention to repeal where express terms are not used?
There may be a presumption that it is not a definitive, it's going to be a case to do this. I would not draft this way. As an attorney, if somebody asked me to draft this, I am not going to, when I know there are other statutes out there that deal with employment law, we shouldn't say that, no, this is the exclusive remedy. Because it sets a conflict.
Right. Well, the Missouri court, and thank you, to speak on the amendment, I'd encourage to vote against this amendment. The Missouri Supreme Court's long held that the repeal of statutes by implication is not favored by the courts, and the presumption is always against the intention to repeal where express terms are not used. To justify the presumption of an intention to repeal one statute by another, either the two statutes must be irreconcilable. To effect a repeal must be otherwise clearly expressed, and that's from State Ex Rel. Hyde v. Booter, Missouri 1928, and has been long held in cases since then. What you have, the specific statutes that are represented that are referenced in here are specific employment statutes. So in those cases, there might be irreconcilable. There might be provisions that this statute needs to speak to provide the exclusive remedy. In the other things that are provided, this is particularly the abortion, pro-life protection. That deals with another subject. I think it'd be quite a stretch for the court to read into this as repealing any such protection for freedom of speech.
Representative Minton?
To speak on the amendment, please.
Go ahead.
With all due respect to my colleague here, I don't think that there's absolutely anything unambiguous about this language. Shall provide the exclusive remedy for any and all claims for injury or damages arising out of an employment relationship. That is absolutely clear. Moreover, if you move later on in the bill, on page 18, we specifically abrogate all of the jury instructions addressing civil actions brought under, now I guess, this chapter. And we are specific, I mean, there's nothing that could be more clear. And if you're saying that this is the exclusive remedy, I think that the court would say exclusive means what it means, which is only. Like our Attorney General, I suppose we could go to Webster's, but I still think that Webster's would side with me on this one. And furthermore, I think that I like the gentleman's amendment because it also could be removing the exclusive remedy aspect of this bill might allow for some of it would give a better chance, I guess I should say, of allowing for actions against the individual wrongdoers, because that is really where the crux of the wrongdoer stuff comes, is that you can't say that you can sue them under another statute as long as you have this exclusive remedy stuff. So thank you, Mr. Chair.
Representative White?
Thank you. Yeah, this isn't, I'm not addressing the freedom of speech issue here. I'm addressing this, I'm trying to get to it, and I didn't get to it quick enough on my phone. The statute I'm referring to talks about termination of employment because you're not willing to do an abortion. Cannot affect your job status. So we're not talking about person's First Amendment right. This 188 point, and I would, if you give me time, I can pull it up, addresses actually the employment situation. Thank you.
Representative Corliss?
Speak briefly on the amendment.
Go ahead, sir.
I want to thank Representative Minton for making absolutely clear what this amendment is about. It's about taking the individual, it's taking the non-liability for individuals, putting it back into the statute through another means. If it was about the abortion issue, the amendment would have specified that. Instead, it wipes out that provision completely, and as Representative Minton mentioned, it brings back in liability to individuals.
Additional discussion. Representative Benton, the second time.
Thank you. Just briefly to respond, but we have seen the Supreme Court weigh in. In fact, I have a quote here that where the statute simply says that, quote, the rights and remedies herein granted to an employee shall exclude all other rights and remedies of common law or otherwise. The court has held that up to abrogate other statutes and to make it indeed the exclusive form. Thank you.
Other discussion? Not appearing.
Oh, Mr. Chair, could I request a roll call?
Roll call you shall have.
Thank you.
Chairman Lamb,
Aye.
Vice Chairman White,
Aye.
Representative Minton,
Aye.
Corley,
No.
Cornejo,
No.
DeGroat,
No.
Albrecht,
Aye.
Carr,
No.
Hill,
Pass.
McGaugh,
No.
Phillips,
No.
Rader,
No.
Roberts,
Aye.
Hill,
Nope.
Chair changes his vote to no. By your vote of 4 yes and 9 no, you have defeated the amendment. Additional discussion. Representative White.
Mr. Chair, give me one more amendment I'd like to offer, please. It ends in point 08H, and I move for its adoption.
Discussion.
Thank you, Mr. Chair. This is a little picky perhaps, but this is a scenario dealing in the medical world that I have seen this type of thing. The provision of the bill that we're addressing here on page 21, lines like 31, is where you have a person, whether it's a CPA, an attorney, someone hired to look for wrongdoing in the company. And they find wrongdoing. The intent of this legislation, which I understand and I agree with, is that that person can't then turn around and immediately blow the whistle and go to the, call the feds, call the Human Rights Commission, whatever, and deal with this. That's not what their job is to find this problem. My concern is, and scenarios happen this way where the person finds wrongdoing. Say, we're selling something to the government, we realize, through your investigation, you realize either we're not selling it or we know there's a defective, we're defrauding the government basically, and the individual reports to their superiors, yes, we're defrauding the government with their evidence. Ah, great, that's wonderful, we'll take care of it, and they don't, because they're involved in the wrongdoing. Under the way the bill is currently written, then when I blow the whistle, if I'm that person, I get fired and I do not have whistleblower protection. That is not, in my opinion, what this bill is intending to do. They want to stop where I'm supposed to find out and I immediately, without telling the company, go blow the whistle. I agree with that. But in my scenario I just described, these people will not be covered. If they do their job, they report, the company ignores, it does not rectify the scenario, they then blow the whistle, which has happened in that scenario. They're out of luck for whistleblower protection. This simply says that after they've done their job, they can't whistle blow, they've actually reported to the company's failed to take corrective action, then they are allowed, if they whistle blow, they are a protected person. or the whistleblower statute. And that's the whole amendment pretty much. Thank you.
Additional discussion. Representative Mitchell.
Just to make a comment,
Go ahead.
I support this amendment. I spoke to Representative White before the committee started, and I actually have the same amendment drafted. So I'd like to say that great minds do think alike. And again, this was something that was brought up in the hearing, and I think that the sponsor made it quite clear that this bill does not protect Missouri taxpayers to the this particular language in this bill does not protect Missouri taxpayers to prevent fraud. And I think that's not, I don't think that's what the bill intends to do, but unfortunately it does indeed. And I think the amendment's very important for that reason.
Thank you, Representative. Additional discussion? None appearing? All those in favor of adopting House Committee Amendment number 4, will say aye.
Aye.
Those opposed, say no.
No.
The noes have it. We fail to adopt the amendment. Further discussion? Martin?
Mr. Chair, I have an amendment ending in 038, distributed last week, I think redistributed again this week. I'd like to offer that amendment.
The amendment number 5. Go ahead, sir.
We had some discussion about this last week with regard to the standards, the language that's being used. And I got some information from House Research. I asked them specifically, I need to get a little closer to the microphone, sorry. I asked them specifically about the standard and the changes. The summary, it's a big long memorandum that was prepared for me by that research department. The short version of it is, if this bill is enacted, Senate Bill 43 would change the standard of proof in employment, housing, and public accommodation discrimination claims brought under the Missouri Human Rights Act. The definition in Senate Bill 43 of, quote, the motivating factor, end quote, which includes the phrase, quote, and had a determinative influence, end quote, would create a standard of proof higher than that used in federal Title VII discrimination claims and closer to the standard used in federal age discrimination claims. So the purpose here, as I understood it when the bill was presented to us, was to bring the standards more in line with the federal standard. What we're doing is exceeding the federal standard. Someone said earlier, I think it was another one of our representatives on the panel today, mentioned the fact that several other states have standards like this or similar to this or exclude individual liability or whatever. And I would like to respond to both that statement that lots of other states are doing this and to the general notion, right? My dad used to say to me when I was a kid, if everybody else was jumping off a bridge, would you do it too? Just because everybody else is doing it doesn't make it a good idea, right? We have an opportunity to shape public policy and do it well. And what we're doing is we're rolling it back to something that we already know didn't work well. We're rolling it back to the pre-1991 standards. I distributed last week those jury instructions, which are what they use in federal court, the federal standard. And those jury instructions say a motivating factor. I can reproduce those if you guys want me to. Like I can have my LA, I hate making her do the extra work, but I can have her run down copies if you want to see them again. Do with this is just to make it a better bill, to bring it in line with the federal standard, and to actually be honest about what we're doing. If we're going to tell people that we're bringing it in line with federal standard, then that's what we should be doing. So, thank you, Mr. Chair.
Additional discussion?
Chairman Lynn. Chairman White.
No.
Representative Mitten.
Aye.
Corliss.
No.
DeGrove.
No.
Albright.
Aye.
Hart. Hill.
Pass.
McGaugh.
No.
Phillips.
No.
Rader.
No.
Roberts.
Yes.
Hill.
No.
Chair will change his vote to no. vote of 4 yes, 9 no, you failed to adopt the amendment.
Yes, Mr. Chair, I have an amendment ending in .028. I'm sorry, I'm jumping the gun.
Okay. Yeah. All right. Okay. Okay, it's 3 yes. And
Yeah.
There were 3 ayes and 10 noes. Representative Roberts.
Thank you, Mr. Chair. Yes, I have an amendment ending in .02H, and I move for its adoption. It's been distributed.
Discussion.
Thank you, Mr. Chair. There's a lot of talk about this in the committee. This adds sexual orientation to the discrimination bill. Everyone says that it's wrong to fire someone based off their sexual orientation, but no one seems to want to act to fix this. In the state of Missouri, we should judge people on their character, competence, and integrity. It's unacceptable that in the state of Missouri you could still be fired based off who you love. Everybody support the bill, the amendment. Thank you.
Discussion. Representative Minton.
Just briefly, didn't the sponsor himself say that he was supportive of Mona?
Yeah, the sponsor himself, him and even a lot of the people speaking in opposition thought that Mona was a good idea. And I'd also like a roll call, please, Mr. Chair.
Thank you, Mr. Chair.
Is there additional discussion? None appearing. Roll call.
Chairman Land. Vice Chairman White.
No.
Representative Mitten.
Aye.
Corley.
No.
Cornejo. DeGroat.
No.
Albrecht.
Aye.
Carr.
No.
Hill.
No.
McGough.
No.
Phillips.
No.
Raider.
No.
Aye.
By your vote of 3 ayes and 10 noes, the amendment fails. Additional discussion. Representative White.
For discussion, please.
Go ahead, sir.
As I pointed out, I had several amendments that we've heard on that I had offered. Something else I didn't offer. Again, I support the idea, and I, with my last, the vote we took, I think the motivating standard, which is a determinative standard, is an acceptable standard. But this bill does more than just reset the clock in that regard. Most of the amendments here are dealing with peripheral items to that issue of what is the standard of the test. One of the other things I did not draft an amendment on that is new in our legislation is the idea that we are going to restrict the amount of damages received or recovered. And it's one thing, I'm not opposed to caps, but the system that this bill puts forth bothers me in that the individual is injured by discrimination, whether it be sexual discrimination, age, race, religion. Somebody puts a swastika in a Jewish person's locker or whatever. You can think of whatever you want. It doesn't make any difference what the damage is to that person up to the cap limit. What determines the amount of recovery is how big the defendant is. If it's, I have to look up quickly, if it's under 100, it's a cap, I believe, of $50,000. If it goes up to 1,000, then it's 100,000, then it goes to 200,000, then it goes to 500,000, if I'm correct. But it has numbers, but it's based on how big the defendant is. It's like getting in a car accident and saying, well, we're going to set the damages not based on what your injuries are, but on how much the guy can afford that had the car that hit you. I mean, that's an exaggeration of sorts, but he gets the point across where I'm coming from. Why are you limited? If someone is wronged in the discrimination case, why are you limited by the size of the defendant? Which is, I'm sure that it equates to the amount of money that they can afford. I mean, the concern is we don't want to put small businesses out of business because of a judgment. But how many, the vast majority, if I'm correct, I haven't seen the numbers in a while, of our employers in this state work for companies that have less than 100 people. The majority of people work for smaller, under 100 companies. Yet, if we have a big company and the exact same discrimination occurs, the person can recover more if their recovery is higher. If they psychological issues they're dealing with, whatnot, it includes punitives, by the way. If you want to separate punitives out, that's a different animal. But that cap covers everything except for back pay and the interest on that back pay. So it's your if you're having to see a therapist, if there is some physical issues you're having to go to, if the idea is that, okay, you're fired, you brought this case, you can't get a job now at your pay level you used to because you're now known as someone who will file a lawsuit. And you therefore are going to have lost wages in the future for a reasonable period of time until this blows over, maybe you move, whatever. Your recovery is based only, once you reach that minimum threshold, it's based on how big the company is. And I don't believe that. And this has not been in our statute. If this were capped and we said $200,000, or if we said $50,000 for everybody, I'm happy, but this breakdown of how big the company is by what you can afford is what you're going to get damaged by, or what the damage you're going to have to pay to the injured person. Just doesn't, again, it bothers my sense of fairness and justice. It shouldn't be this. If this is proven guilty, there has been discrimination. There's been a firing, wrongful firing. We should be looking at that incident, not how much the other person can afford. So that's one of my oppositions to the bill. I didn't do an amendment on it because I already thought 2 was adequate. But I want to run that by people to keep in mind. Thank you.
Representative Albert. Go ahead, sir.
I know we've gone through a lot of amendments and people are probably sort of done listening. And I know the numbers are probably going to be on the losing side on this thing, but I want to explain why I think every one of us should probably be voting no on this bill. It was presented by a senator who is currently being sued for this very thing. Now, by our constituents, with a very awesome authority. We are supposed to shape public policy to make Missouri a better place. That's what we're asked to do when we're sworn in. And we take an oath and we make a promise to God that we will do that. And to have a senator introduce a bill that is so evidently self-serving is offensive, and it tarnishes our honor by participating and allowing him to advance this legislation. I encourage the body to vote no for our own honor's sake and for the oath that we took. This is serious stuff.
Thank you, Representative. Additional discussion? Not appearing? Oh, I'm sorry. Representative Corley.
Thank you. Mention a couple things on the caps. I think it was mentioned that Representative White did mention that the caps did not include the damages for back pay, and I think we need to be clear about that. That again, this is an employment case, and the employment, the pay, is not capped in any such way. Some of those other things he mentioned, I think, could be recovered in workers' comp as well. When they're forced against you, intentional, when you have emotional distress, things of those nature, you can also make workers' comp claims. It's also important to realize that this, although follows the federal case or the federal caps, there's an allowance for more damages under our provisions that are here. Finally, with respect to the last comment, I mean, I think it's clear we went over this before, that provisions in this bill that retroactively go to an existing case. I think that's an unfair argument, and it's in no way. I think we addressed that previously, but there's no provision in here that retroactively would apply to an existing case.
Additional discussion? Representative Roberts.
Thank you, Mr. Chair. Let's make one thing clear. I mean, there are no damage caps and discrimination cases based off race. So to say that we're bringing this in line of the federal standards is completely incorrect.
Representative Minton.
I also just want to quickly address the cap comment, is that Representative White did not talk about, he wasn't talking about back pay. He said that it allowed for back pay. What he was talking about was future pay. And I believe that we even had someone testify about white male who was wrongfully terminated and collected, I believe, a pretty significant amount of back pay. Right, and I know that we had a spouse testify as to the very same thing. So that future earnings is very important, particularly to those who are over 40 and terminated because of age. And God willing, all of us in this room will be over 40 one day, right? And further, I'd just like to, again, thank Representative Elbach for his comments, because I think that they're very heartfelt. And I would hope that everyone in this room could understand the significant differences that are going on here. And like it or not, you can say that it brings us in line with the federal standard, and it's just not true. Saying it over and over and over again does not make it true. And at the end of the day, this bill hurts our constituents. You can argue that it's going to help our businesses, but it's going to hurt constituents, and it's not going to change the behavior or the culture. That's the important thing, is that we need to be focusing on trying to change the culture and change the behavior. And by letting wrongdoers get away with it, it doesn't change anything. To pass this bill out of committee during a Sexual Assault Awareness Month, I find particularly reprehensible, and I will vote no. Thank you, Mr. Chair.
Representative Elbrecht for a second time. Go ahead, sir.
There will be future lawsuits, public accommodations lawsuits, and hostile work environment lawsuits. If he wins the petition that he's got filed against him right now, he'll get sued again and again and again.
But two, if he tolerated that, if they prove it, he should get sued. He should get shut down.
Additional discussion. None appearing, I now move that Senate Substitute Number 2 for Senate Committee Substitute for Senate Bill 43 be voted to pass. Any discussion? Please call the roll.
Chairman Lamb.
Aye.
Vice Chairman White.
No.
Representative Minton.
No.
Corliss.
Aye.
Cornejo.
Aye.
DeGroat.
Aye.
Elbrecht.
No.
Harr. Hill.
Pass.
McGaugh.
Aye.
Phillips.
No.
Rader.
Aye.
Roberts.
No.
Hill.
Aye.
By your vote of 8 yes and 5 no, you have do pass. Senate Bill 43. That concludes the hearing. Thank you very much, ladies and gentlemen.
Sorry?